As we just read about on the online course page, there are 6 permitted reasons for the use and disclosure of protected health information, PHI. Those are to the individual directly, for treatment, payment, or health operations, for situations where the patient has an actual opportunity to permit or object, incidental uses, limited data sets such as for research, and for public interest and benefit activities. For the category of public interest, there are actually 12 national priority purposes to review for this category, which are focused on public interest uses outside of the healthcare context. Those are what we are going to cover in this video. Next are those uses required by law. Covered entities may use and disclose PHI without individual authorization as required by the law, including things like statutes, regulations, or court orders. For chiropractic, personal injury cases like car accidents or even workers' compensation could fall under this category. Public health activities. Public health authorities include those organizations that are authorized by law to collect or receive information regarding the prevention or controlling of disease, injury, or disability, and to public health or other government authorities for cases involving things like child abuse or neglect. FDA regulation for product tracking, reporting, recalls, or the like also fit here. That piece could come into play in some offices that carry certain products or supplements. Exposures to communicable disease also fits under this category when dictated by law. Keep in mind, not all disease gets reported, but rarer conditions or diseases like pertussis, whooping cough, for example, are supposed to be reported. These, however, typically fall under the umbrella of a medical doctor who prescribes medications and treatment for the disease. The big one on this slide for chiropractic offices is employers. If an employer is calling the office looking for information about their employee, the huge take-home point here is that for general care, the employers have no right to PHI for employees. However, if an employee has a work-related injury, illness, or workplace-related medical surveillance, e.g. a workers' compensation issue, then records must be given when requested. Many chiropractic offices see a lot of work comp, and keep in mind that in those cases, the employer may need to request the records in order for them to comply with standards set forth by OSHA, Occupational Safety and Health Administration. This slide is pretty self-explanatory. Chiropractors are mandatory reporters for abuse, so in such circumstances, entities may disclose PHI to appropriate government authorities regarding victims of abuse, neglect, or domestic violence. That is accomplished here in the state of Iowa through the Department of Health and Human Services. Health oversight activities. Covered entities may disclose protected health information to health oversight agencies as defined in the privacy rule. For purposes of legally authorized health oversight activities, such as audits and investigations necessary for the oversight of the healthcare system and government benefit programs. Think things like Medicare and Medicaid. The law is the law is the law. If a request for PHI is made through an order from a court or administrative tribunal, then covered entities may disclose PHI in a judicial or administrative proceeding. Such information may also be disclosed in response to a subpoena or other lawful process if certain assurances regarding notice to the individual or a protective order are provided. For PI cases, such as car accidents, DCs may very well be deposed or summoned to testify if they are an expert witness or otherwise involved in the care of someone involved in a lawsuit. Covered entities may disclose PHI to officials for law enforcement purposes under the following 6 circumstances and subject to specified conditions. Number 1, as discussed on the previous slide, as required by law, including things like court orders, warrants, or subpoenas. Then we become part of CSI or Magnum PI. Number 2, to identify or locate a suspect, fugitive, material witness, or missing person. Number 3, in response to a law enforcement official's request for information about a victim or suspected victim of a crime. 4, to alert law enforcement of a person's death if that covered entity suspects that criminal activity caused the death. Number 5, when a covered entity believes that protected health information is evidence of a crime that occurred on its premises. And number 6, by a covered health provider in a medical emergency not occurring on its premises, when necessary, to inform law enforcement about the commission and nature of a crime, the location of a crime or crime victims, and or the perpetrator of the crime. The term decedent means the individual has passed away and that the individual with PHI is deceased. Note that decedents are still covered by the protection and rules of HIPAA. Just because they died does not mean you can start talking about them to others in a personally identifiable way. Covered entities may, however, be expected to disclose protected health information if requested to coroners or medical examiners to identify a deceased person, determine the cause of death, and or perform other functions authorized by law, and possibly to funeral directors if so requested. In a chiropractic office, an example may include X-ray information that might depict a certain anomaly of the spine or a condition that could help identify a deceased individual. Tissue donation. Just as it sounds, covered entities may use or disclose PHI to facilitate the donation and transplantation of cadaveric, meaning from the cadaver of a decedent, organs, eyes, and or tissue. This is not something chiropractic offices would typically be involved in, but it is one of the 12 permitted uses of information to be disclosed. Research. This is an area that chiropractic offices may participate in. Research is any systematic investigation designed to develop or contribute to generalizable knowledge. It is always best, out of respect for the patient, to simply have a conversation about if you feel their case would contribute to research. However, a covered entity can use and disclose protected health information for research purposes, even without an individual's authorization, provided the following: if a waiver of authorization from a review board is obtained, or if PHI is necessary for research and assurance is given that the researcher will not remove any PHI from the entity, if documentation of death is sought out in those select cases, and if only a limited data set is used where some of the personally identifiable information is removed from the data before it goes to the researcher. Covered entities may disclose PHI that they believe is necessary to prevent or lessen a serious or imminent threat to a person or the public, and they can help prevent or lessen the threat, including the target of the threat. Covered entities may also disclose to law enforcement if the information is needed to identify or apprehend an escapee or violent criminal. Again, a rare case in a chiropractic office. An authorization is also not required to use or disclose PHI for certain essential government functions. Such functions include things like assuring proper execution of a military mission, conducting intelligence and national security activities that are authorized by law, providing protective services to the President, making medical suitability determinations for U.S. State Department employees, protecting the health and safety of inmates or employees in a correctional institution, and or determining eligibility for or conducting enrollment in certain government benefit programs. Workers' compensation. Covered entities may disclose PHI as authorized by and in compliance with workers' compensation laws and other similar programs, providing benefits for work-related injuries or illnesses. Many chiropractic offices routinely work with work comp cases, and this is an exception for authorization that many of you will implement regularly. Remember here that though in general a patient's employer has no right to an individual's records, if the patient was hurt on the job and this is a work comp case, the employer can request and be granted information about the patient in order for them to comply with OSHA standards. So as a quick recap of these 12 categories of exception: required by law, public health activities, victims of abuse, health oversight, judicial proceedings, law enforcement, decedents, cadaveric donation, research, serious threat to health or safety, essential government functions, and workers' compensation. A few of them in particular are routinely utilized in our chiropractic offices. For personal injury cases and workers' compensation cases, many chiropractors routinely see these types of cases and may be required to share records to attorneys, case reviewers, for court depositions, and the like. Research, audits, and cases of abuse or law enforcement purposes may be much more less likely encountered, but still a possibility. These 12 exceptions are important to know because they do not require the individual's permission or authorization. However, again, in the spirit of service and respecting the patient, I would personally recommend that the DC politely let individuals know when you've shared their health information with another entity and that you were required to do so because of their PI or work comp case status.